Good afternoon, everyone. We have a packed courthouse, packed courtroom. So we have 20 hours of requested arguments. Before we get started, I want to acknowledge Mr. Ruhan Bohan, right, who is a rising junior from Baruch College, and he is interning here with AD1 this summer. So I will, as you all know, please ask for the time that you actually need in order to get out the salient points of your argument. Please keep in mind that we have read your briefs. We are fully familiar with your arguments. People v. Joaquin McCall. Submitted. Toomer v. New York City. Really? Yes. 514. Madam, Giselle, and Alexis. Submitted. People v. Dante Thomas. 515. Chapman Capital v. Platinum Asset. 623. People v. Shanasia Frazier. 414. Woman v. Seven Seas Union. Submitted. People v. Jose Maldonado. That matter is submitted. People v. Juan Sims. Submitted. Palmer v. City of New York. Submitted. Arena Limited versus Chalet LLC. Submitted. Weiss v. Amtrust North America. Submitted. Idahosa v. MFM Contracting. Submitted. First case for argument, 1 of 4. Toomer v. New York City Housing. Whenever you're ready. I'm going to be nice. I'm going to start all over again because I had you running, your time running, okay? You ready? Go.
Good afternoon, Your Honors. Jillian Rosen for the plaintiff appellant. In this case, the defendant wasn't entitled to summary judgment because this is not an issue of just general awareness of a dangerous condition. There's overwhelming evidence of a recurring dangerous condition that was routinely left unaddressed. And in support of summary judgment, the defendant's own evidence establishes that.
Weren't they routinely sweeping or cleaning the stairs, and didn't they clean the stairs on that day, on the day of the occurrence itself?
Well, they said that they did that at 9 in the morning. The issue is, if you look at 381 of the record and 382 of the record, that's the caretaker.
What day of the week was this?
Sunday.
Sunday.
And it was a couple of days after Thanksgiving, right? Thanksgiving was the 23rd, and this occurred on Thanksgiving was that Thursday, and this was the Sunday.
Correct.
But in terms of the cleaning, they had cleaned it that morning, and then this allegedly occurred at 7:45 p.m.
Right, and so our position is we don't know what was done. I mean, Mr. Roberson did not fill out, if you look at 382 of the record, this caretaker checklist was submitted and completed by Santos, who is...
But didn't she was the supervisor, right? And she said that she filled out these checklists based on the information that was called in by the caretaker, Mr. Roberson.
Correct. The only issue is that Mr. Roberson doesn't recall doing an inspection that day. He doesn't recall what he had found that day, if anything. And
but didn't he say that he would, on Sundays, they did one walkthrough around 9 o'clock in the morning, I think that's what, and they left at 1 o'clock, if I recall. And he says that if he had found any debris, he would have cleaned it up. If he had found a light bulb that had a problem with it, he would have changed it. I mean, he doesn't remember exactly what he did, but he said that that was his routine. What's wrong with that?
Well, our position is that we don't know if the janitorial schedule was followed because we don't know what, all it says was perform safety walk down of building. It says yes, but we don't know what that is. We don't know what he did, what he found, what the condition of the stairs was, but we do know that We have evidence
But
showing.
there is an actual record of him having done an inspection on that day.
There's evidence that, I mean, there's evidence that he did it after he was shown the caretaker log. He didn't recall even looking at the stairs that day, but then he was shown this. He said, "Oh, I must have done it." But Santos actually, before we get to our witnesses, Santos actually testified that there should have been 2 walk downs. There should have been one at 9 a.m. and one at noon before they left for the day on Sunday, and that wasn't done. So here we have the supervisor of Mr. Roberson actually saying there should have been 2 walk downs and there was only one. And what we know is, even though Mr. Roberson has no recollection of what the stairs looked like and what he did and whether the janitorial schedule was followed, we do have affidavits from Mr. Villa and Mr. Brecker, who one of them lives in the building and took photographs right after the plaintiff fell and testified, and the affidavit states that there is a recurring condition, constant garbage and debris in the staircase, and Ms. Santos, which I think this is the most compelling of all, is that Ms. Santos, who's Mr. Roberson's supervisor, testified that she advised her supervisor of the recurring debris and dangerous condition in the staircase 20 times between August of 2017 and December of 2017. That time span encompasses the state of accident. So we have the
Well,
only...
it wasn't so much a dangerous condition. It was that she had received over 20 complaints, I think, of debris on the stairwells. But to that point, is there anything in the record to suggest that NYCHA did not take proper precautions or take some precautions in terms of alleviating the situation?
In response to that, I would say the fact that this is recurring and has been that Ms. Santos reported this condition at least 20 times is one indication that they didn't do anything. The other indication, because if it was remedied, then it wouldn't be
Well,
constantly...
yeah, but the question becomes, how do you remedy it? Because the cause of this, according to NYCHA, and according to all involved, actually, is that it's the tenants who are throwing bags of garbage in the stairwell, and or if the garbage chute is not working, they're manually taking the garbage down the stairwell. So how do you remedy that situation? How do you prevent the tenants now from throwing garbage on the stairwells?
Well, with regard to the chute, I mean, we do have Mr. Villa. I think it was either Mr. Villa or Mr. Brecker did say in the affidavit the reason why the staircase was bottled up with furniture and debris and garbage was because sometimes the chutes were broken. That, to me, that's on NYCHA to have an appropriate way to dispose of their garbage. In addition to that, to respond to, should I do that in reply or my light's up?
Yes, on reply.
Sure, thank you.
Thank you.
Good afternoon. May it please the court. Patrick Lawless for defendant respondent NYCHA.
So this is an ongoing problem. We have had, I don't know how many cases wherein there is debris, garbage, et cetera, on the stairwells in NYCHA buildings. So, and this particular location, the supervisor, Santos, testified that she had reported the complaints of the caretakers, et cetera, approximately 20 times before the accident. So, I mean, you're aware of the situation. What have you done to remedy the situation?
There's a regular cleaning and inspection schedule in place, and as Your Honor had pointed out, this is the tenants doing this, and it was regularly addressed by NYCHA. The plaintiff submits affidavits from a tenant and the plaintiff's friend, but neither of them say that NYCHA didn't address it. To the contrary, actually, the plaintiff's friend, Mr. Villa, claimed that he worked there and that he was regularly cleaning the building. So that combined with Mr. Roberson's testimony, which he unequivocally testified that he did perform an inspection that morning.
What
You also
about
said that you were supposed to conduct 2 that morning. There was one that was supposed to be done at 12 o'clock.
I think that doesn't matter. I mean, this court has found in similar cases, there's a case by this court, Pagan, and in Pagan, it was a weekend schedule. It was an accident that occurred at 7 a.m. the next morning, on Monday morning, and the caretaker testified that they performed an inspection on that Sunday at some point before 11 a.m. So there was a 19-hour interval between the last time the stairway was cleaned and inspected to the time of the accident. And this court said NYCHA doesn't have an obligation to clean 24 hours a day. And the fact that Mr. Roberson may not have followed an internal procedure is not a basis for finding NYCHA liable, especially when there were daily inspections in which this court has found that they were adequate.
What about Ms. Rosen's point that this was a recurring condition, at least in part because the chutes, the garbage chutes, didn't always work, and so the tenants may have had no choice but to bring their garbage down and had no place to put it, and that's on NYCHA?
Well, that was, I believe that was in Mr. Villa's affidavit, and he said he had worked there years before, so he said that was a problem years before. We don't know, there was no indication in the checklist that there was anything wrong with the chutes that morning, and there's nothing to indicate that. This isn't just isolated to this development. This happens in all NYCHA developments, and what NYCHA has in place is the regular cleaning and inspection schedule. And the plaintiff, and the papers below, did not contest that Mr. Roberson performed an inspection of the stairwell that morning. And he described exactly what he did. It wasn't vague. He said when he performed the inspection, if he encountered any garbage or debris on the stairs, he would have immediately cleaned it. If there were any outages in the light bulbs, he would have reported that to his supervisor, and then he would have replaced the light bulbs. So based upon this, NYCHA established that it didn't have notice.
Sir, what's the distinction between a general awareness of a hazardous condition that cannot serve as the basis for liability and a knowledge of a specific recurring hazardous condition that can?
Well, I believe a general awareness is notice of a condition, but it's regularly addressed, and a specific condition which is unaddressed, I believe, prior cases have found like recurring leaks and things like that to be a recurring condition, where a transient condition such as garbage, which is regularly addressed, does not constitute a recurring condition. Thank you.
Thank you.
I just want to go back to the question that you asked me, what NYCHA could have done. I mean, in addition to keeping the premises in a reasonably safe condition and the garbage chutes working, which is obviously where...
Well, was there any allegation? I didn't see anything in the record. You mentioned lighting because the plaintiff there was some indication that perhaps the lighting was inadequate. But was there any allegation that the chutes were not working, the garbage chutes were not working, and had not been working for a period of time?
Not from Mr. Roberson or Ms. Santos or the plaintiff. The plaintiff didn't live there. Mr. Villa was the one who said that, and I believe it was either Mr. Villa or Mr. Batcher. Mr. Batcher.
But that had been years before. Was
Yeah.
there anything that the chutes had not been working that particular day or that week or that month?
Not that day, no. Just that's just evidence of perhaps the reason why this condition recurred. It's just evidence. I mean, I just have to raise an issue of fact to defeat summary judgment at this point. But with regard to what they could have done to remedy the situation, could have been, it's actually an issue of fact for a jury, whether there should have been 2 on the weekend, considering that Ms. Santos, who's the supervisor for Mr. Roberson, said that there should be 2 even on the weekends, probably because going from 9 a.m. till the next day may not be sufficient in light of the recurring condition. 1 walk down, my adversary argues that 1 walk down is enough, it's in his brief, but the 1 walk down may not be enough when the condition is recurring like this is. With regard to Pagan, by the way, the case wasn't a recurring condition. The better case that I think is really on point, which is in my brief, is Lopez against New York City Housing Authority by this court. And this is where there was a frequent accumulation of garbage on the staircase. And this court says the defendant mischaracterizes plaintiff's proof in arguing that at most it shows a general awareness. Rather, plaintiff's proof tends to show that defendant negligently maintained the staircase by failing to have in effect a cleanup schedule sufficiently frequent to avoid the creation of the dangerous condition.
I mean, Lopez, you're right, sort of seems to support that position, but it is a pretty old case and has not been cited for
Right,
a long
Lopez.
time, and it seems that our recent case law may not have been going in that direction.
Lopez was 1998. It really has not been cited. And in fact, we decided Barris v. NYCHA, which was in opposite, not so much in opposite, but did not follow Lopez.
Okay, but,
Thank you both.
okay, thank you.
People v. Dante Thomas. I know. Yes, you may proceed.
Good afternoon. Allison Haupt for Dante Thomas. When the police sidled up to a group of teenagers walking down the street.
What did they do? What, they saddled?
Sidled?
Oh, sidled. I thought you said they saddled up. I was like, I missed that.
No.
Yeah.
But to be even more specific, as they drove up and
They drove up, they said, hey, how you doing? There had been a shooting reported earlier, I think,
sometime that day.
and so they sidled up and they said, hey, how you doing? And the defendant, responded, right?
So they did more than just say, hey, how are you doing?
Oh.
They said, hello, police. They announced themselves as police. They stopped their car in front of the first group of teenagers. And when they tried to continue walking, they kept on driving up. They stopped the second group.
I thought they just said hello.
And the first group kept walking after they responded to
Right.
the officers, right?
And the police didn't give up even after that. They kept
What do you
on
mean?
driving.
They left. They proceeded on. Your client was a part of the second group.
I mean, these are two small clumps of teenagers that are together.
What do
Yes,
you mean
kept
they
on
didn't give
driving.
up? They can't say hello to folks on the street?
Well, if you're going to announce yourself and say, hello, police, if you're going to call out the window, that's a level one.
Are they in a marked police
encounter.
car?
It's an unmarked car, but it's still level one. And
Are you
responding-
arguing that that's a seizure?
Well, I'm arguing that it's a level one and that it's
How is it a
inception.
level one?
Well, first, respondent conceded that it was a level one. It's at page 90 of the hearing minutes. They said that saying hello, police, we believe the people are arguing that this is a level one. So that's
Right.
what
So what happened thereafter?
So
after
they-
this alleged level one stop.
Well, they don't have an objective, credible reason at the point at which they engage in this level one conduct. They're calling out, hello, police. They're snapping and waving their hand out the window. And at this point in time, all
What
they know-
evidence do we have of them snapping and waving their hand?
the
outside?
body cam video where you can see the hand, and the court describes that in its decision. The court is describing, it's not actually defense counsel saying so, that the hand is reaching out and you can see it out the window, calling, directing at it. And at this point in time, when you see Dante, he's walking straight ahead. His left side is to the police car. They're saying that the Beats headphones are in his right hand. And so it's only after the car stops, after they yell, hello, police, after they snap their hands, that he moves his body towards them. So even to the extent that the court accepts the idea that the officer saw this L-shaped bulge at 10:40 p.m. at night in a matter of seconds, that happened after the police already engaged in that level one conduct. And at the point at which they did that, all they know is that a shooting occurred 2 blocks away near the Grand Concourse. It's a mixed residential and commercial area. People are obviously around this neighborhood. This shooting could have been 12, 14, 20 hours earlier than the point at which Dante is stopped. It's interesting to note that respondent never claims that the shooting in and of itself would have given permission for the level one. They couple it with this L-shaped bulge, which of course the police did not know at the time that they engaged in that conduct. And so this court has to look at the conduct at its inception and whether they had the objective, credible reason at that time, which the police didn't have. It's
Do we even have to look at that? I mean, isn't the threshold question, which, has not been addressed, as to whether or not there was a valid waiver of his right to appeal?
Well, the appeal waiver is not valid, which is why this court should reach the suppression issue.
And why is the appeal waiver not valid?
There are multiple issues with it. The fact that Dante is required to allocute to the crimes before the court explains
And I
the
think
appeal
we've
waiver.
said,
Otherwise-
right, we've said previously that that is not a basis to invalidate the plea.
Well, oftentimes it's not dispositive, but of course this court looks to the totality of the circumstances. You have an extremely young client, somebody who has never had any experience with the criminal justice system before. The court actually commented on how young he was. At a point in time in the record, you can see that he doesn't quite understand. He asks for clarification, and the court responds sort of in this jumbled way that, as I said, I'm going to pull it up here if you would bear with me. Do you waive your right to appeal in return for what we talked about that I promised to give you today on these pleas? That's the answer to him saying, excuse me, can you clarify that for me?
And was it clarified?
To say that in return for what we talked about that I promised, when there's no confirmation did he understand the explanation, there's no confirmation that he understood that he was entitled to an attorney, even with the appeal waiver, that he's young, he's inexperienced.
He was
has these
represented by
questions.
counsel?
He was represented by counsel.
At any point, does he again stop the court and question or ask exactly what the court is asking or state that he does not understand?
He does ask for clarification, and again, the court responds in that sort of convoluted way. When you have,
Did he again say, I don't understand what you just said, that was convoluted?
he didn't, but there's no requirement to say, whoa, whoa, wait, I don't understand here.
But I
The court
mean,
has
in order to make an argument that he didn't understand, don't we have to have him stating he did not understand?
But the finding isn't, did he not understand? Can we be comfortable that this young client, never before exposed to this information,
Unfortunately, we have a lot of
voluntarily-
defendants who are young, but he was represented by counsel, and so, I mean, should counsel, is there no responsibility on counsel to assist him and counsel him if there's an issue?
Well, there's no point at time that the court asked Dante whether he understood the explanation from counsel, and certainly counsel is present all the time, even in cases where this court has invalidated the waiver.
Apparently, the court explained the 4 claims that would survive the waiver, told him the rights he was going to give up, and there was also a written right to appeal as well, right?
But a written waiver does not absolve the court of the responsibility to clarify, to make clear, to have the order be important. No, it's not dispositive, but it's relative to the age and the experience. This, normally you would get an attorney. Normally you'd be able to have that, but with this waiver of the right to appeal, making it seem like in these limited claims you don't get the right to an attorney. There's enough question here when you have a more vulnerable client that this court has, and we cite to those cases in our briefs, where you've found an appeal waiver invalid with
So
a
how
young
old
client like
how
this.
old was he at the time of this incident?
19 years old.
And you're talking about vulnerability in terms of his age. Is that what you mean by vulnerable?
Wait, yes.
Thank you. You have time on.
Thank you.
rebuttal.
May it please the court, Oliver Lee for the people. Good afternoon, everyone. Your Honors, this court should not review defendant's suppression claim because defendant validly waived his right to appeal.
Was the response really jumbled up, or was it not in response to the defendant asking the court to repeat one more time what he said?
During the plea colloquy, Your Honor.
During the waiver of right to appeal colloquy portion.
Yes, so the colloquy was not jumbled. In fact, it mirrored the model colloquy, which has been endorsed by the Court of Appeals. During that entire model colloquy, the defendant never once indicated that he did not understand, except for that moment which the court clarified. Furthermore, the defendant signed 2 detailed written waivers, both of which explicitly mentioned that defendant waived his right to review of his suppression motion. Furthermore, he confirmed that he discussed them with counsel before signing. This is on page 12 of the plea. Defendant also received a very lenient plea in the sense that he received an aggregate 2 years of imprisonment and 2 years of post-release supervision.
But it's the first arrest, right?
There were 2 cases. The hearing case was his first arrest, but he took a plea to both cases. So for both of them, he received an aggregate sentence of 2 years of imprisonment, 2 years post-release supervision, when he could have received consecutive 15-year terms.
And it's 2 cases for firearm possession, right?
2 cases for firearm possession, yes, Your Honor. 2 violent felonies are what he was charged with.
So what do the people say? The police approach and say, hello, police, or something to that effect? And what did the police see at that point?
So at the point, after they say hello, they do see a defendant holding an L-shaped object. When they then approach him, he then throws that L-shaped object over a fence.
So what do you, counsel was speaking about, that they're snapping their fingers at him, or what's your explanation on that?
Well, so firstly, whether or not he's snapping his fingers is not proven in the record.
Well, your friend stated that it was in the body cam that the officer is waving, hello, police, and that the officer is waving the defendant over.
So the officer states that he says hello and his partner says hello, police. The body cam shows that after this point in which they see the weapon, then when the car stops, Officer Figueroa is the one that sticks his hand out of the car, but there is no testimony to indicate that he was signaling for defendant's attention. He really could have just been sticking his hand out of the car.
That's after they see the L-shaped object.
That is after they see the L-shaped object. They signal for his attention after they see the L-shaped object.
Did the people concede at the hearing phase that at the point of the signaling that was a level 1 seizure?
So, Your Honor, we would argue no, that they did not concede that. They made a general argument that the entire police conduct was lawful. Before they talk about saying hello, they also talk about the L-shaped bulge. So they're generally saying that after seeing the L-shaped bulge, they could initiate contact. If they did say hello beforehand to initiate the interaction between police, that is not a level 1 interaction. They're not requesting information at all. They're simply greeting.
Well, is that the indispensable element of a DeBoer level 1 is a request for information?
Request for information? Well, certainly yes, Your Honor. I mean, a level 1 interaction is a request for information based on an objective, credible reason. So a greeting and
Am I correct that what you're saying is that for a police officer to say hello to someone, he doesn't have to have any reason?
no, Your Honor, they don't. They can simply greet anybody on the street.
And that's not a request for information, is it?
It is not a request for information. And contrary to my adversary's assertions that this case is anything close to the sham greeting cases that they cite to, there's no evidence that they elicited this interaction for anything other than to elicit a greeting.
You said to elicit a greeting?
I'm sorry, to initiate a greeting. Sorry, not
just
elicit.
to say hello.
Just to say hello, exactly. So in any event, the hearing court's credibility findings should also be affirmed. Officer Pineda testified truthfully and accurately. Here, the court viewed the body-worn camera footage, which corroborated Officer Pineda's description of the scene in that it showed that the streets were well lit by street lamps, they were clear of traffic, and that Officer Pineda was seated in the backseat of a car 3 to 5 feet from defendant when he observed him holding the gun. Additionally, during cross-examination, the court saw that the gun made a visible L shape inside the bag, and the court observed Officer Pineda's demonstration of how defendant held the L shape.
The court observed that because defense counsel requested a demonstration of the actual firearm and the bag that it was contained in, right?
Yes, and they submitted both the bag and the gun into evidence so that the court could
But
view.
there was a demonstration conducted in the courtroom by the police officer, by
Yes.
Officer Figueroa, right?
Yes, there was.
Thank you.
Thank you, Your Honor.
Your Honor, I'm quoting from hearing page 90. This is the prosecutor. He, meaning Officer Pineda, described that the only words that were exchanged were when they were in the car was something along the lines of "hello, police," which I believe and the people argue is just a level 1 stop, level 1 DeBoer. Respondent agrees that after saying "hello, police," that's when they saw the L-shaped bulge. So at the point at which they said "hello, police," which respondent agreed was a level 1, all they knew was about this shooting.
But is hello police any kind of request for information? Is that an inquiry? And if they would have continued walking like the other group, they would have been permitted to continue walking, right?
So it's not that you have to solicit specific information. That's not the barometer of a level 1. And we show People versus Savage, for example, in reply brief, where it's going up with saying, announcing yourself, "hello, police." Yes, that's a level 1. And that's, in fact, frankly, what respondent admits is the case. But it also what respondent argues about the snapping being after the point in time which they saw the L-shaped bulge, that's just not supported by the record, and the body cam actually shows that. If you look at the first group is stopped at 11 seconds. The teen takes an ear out. They're already saying "hello, police" to that group of teenagers. They start driving again, slowing at 24 seconds. At 30 seconds, the car stops at them. At 32 seconds, the officer snaps out the window, seemingly calls out "hello, police," because Dante turns his head. And then afterwards, he turns his body. And then you see shuffling of the officers moving around within the car and then going out to stop them. What that video shows is that stopping the car, saying "hello, police," waving your hand out the window, which you can see on the body cam, that happens before there's any possibility that
Well,
they
no,
saw
you
an
said they're
L-shaped build.
shuffling within the vehicle. Isn't the
After.
shuffling? Right, so isn't that because they then see the L-shaped object?
After the snapping, exactly. What you can
But that's
see.
assuming that the snapping, or what you refer to as a snapping, is some type of a stop.
Well, it doesn't need to be a stop. If it's a level one, if it's a level one to call out, hello, police, to stop, call out the window, to direct towards them. If all you know at this point in time is that some shooting occurred in the neighborhood, it's not enough
So
for there
your
to be a
position
high-crime
is
area.
that the police should, or would be precluded from yelling out hello to individuals on the street?
Just saying hello, the cases that respondent cites to you, just, oh, hello, just a friendly greeting, we're trying to have community.
So it's the hello plus the snapping.
And the police, announcing
So
yourself
they
as
shouldn't say police.
That's different than just saying, I want to have a friendly greeting. They testify that they're
So by saying
patrolling
police,
this area.
so by announcing that they're police officers, this somehow changes it from a hello to something different.
Yes, and you can tell they're not, they said hello to that first group, and that was insufficient. It's hello, it's announcing yourself. And the cases, Savage is directly on point, but even the cases that respondent cites to, that's when they're not talking to them. One of them, they're just following behind and not saying anything. Thornton recognizes that a greeting that's not really meant as a greeting, if it's meant to be police announcing that we're interacting with you as police and not just as friendly community neighbors, that's different. That's not the same thing. And what you can see is that Thornton and Savage and all those cases support that when the police are saying, I'm police, I'm calling you over, it's not just friendly neighbors chatting with one another. We're now at a level one, which frankly, respondent has already conceded.
Interesting. Thank you very much. Thank you both. Chatham v. Chatham Capital v. Platinum Asset.
Good afternoon, Your Honors. Ariel Busquilo of Berkovich and Busquilo PLLC, appearing on behalf of the plaintiff appellants. The lower court simply got it wrong in denying Chatham's motion for summary judgment and granting the respondent's motion for summary judgment. At all times, the parties, Chatham and PRFG, were operating under a master participation agreement. This MPA granted Chatham an ownership interest in its pro rata share of a specific funding agreement with respect
what
to the clients.
language do we have in the MPA that supports that it was an ownership interest rather than a share of the returns?
Well, it's not a profit-sharing agreement. It's a participation agreement. Participation agreements transfer ownership to co-investors. Specifically, the MPA states that PRFG was entering into transactions alongside a group of co-investors, such as syndicate partners, which includes Chatham, and being that the parties entered into these agreements side by side, the agreements were not effectuated until funding was actually provided, and that funding wasn't actually provided to the specific clients until the monies were received from the participants, such as Chatham.
What evidence was there in the record that Chatham was the sole owner of the Chatham purchased receipts, as opposed to a participating owner or something else?
Well, they were a sole owner of their receipts, which was a percentage of the subject agreements. The assignment agreements between PRFG and SPV, under which an interest was assigned to SPV and further collateralized or secured against for the ARENA credit agreement, specifically states that PRFG was only assigning a percentage of each agreement. There's a table, a schedule at the end of each assignment agreement which specifically states PRFG ownership. They noted that they only owned, whether it's 70%, 30%, or 80% of
But
any
how does
specific
that
contract.
lead to an actual ownership by Chatham versus some sort of interest in a pro rata share?
Even if it's not an ownership interest that Chatham would have, it's still an interest that's superior to the interest that ARENA would have had, because ARENA's interest was only in the collateral that was owned by SPV, and SPV never took ownership or never took assignment of an interest other than what was specifically stated on the schedules. Those schedules specifically provided that only a percentage of each agreement was transferred. The remaining interests were owned by the subject participants, such as Chatham.
Sir, you started your argument with your Chatham's interests are governed by the MPA, correct?
That is correct.
So how do you deal with paragraph 4.2?
Well, with respect to the MPA in general, right, the MPA confers a right to Chatham to its pro rata share of the proceeds that come in on any specific contract, which is its pro rata, which is linked to its pro rata ownership interest.
Well, first it says you have a right to a pro rata share of the collections,
Well,
and then the collections are defined, short, a couple pages before, and collections are defined as proceeds of purchased receivables.
well,
Now we're a couple steps removed from the actual purchased receivables themselves.
well, not necessarily, because the purchase receivables were purchased by PRFG under the operating agreement, under the operative funding agreement, and that specific interest is what Chatham participated in on the participation
But
agreement.
what the MPA gives Chatham is only a pro rata share of those receivables, not an actual ownership interest in the receivables.
In
Based
any
on that
event,
language that we just heard.
well, even if the right was only a right to the proceeds of specific collateral, Arena is unable to argue that they take an interest superior to that which SPV had by virtue of their Article 9 sale. Because as an assigner, as an assignee, SPV was only able to take assignment of whatever interest PRFG had. PRFG's interest was limited to their right to receive only their pro rata share, and they were still contractually obligated to remit the pro rata share that Chatham was entitled to receive.
But it's
under
ultimately the
MPA.
pro rata share of what? Is what
Well,
we
it's
have to
the
nail
pro rata
down
share
first.
of whatever.
Instead of sort of looking at it, what other people's, what other entities' interests were, what were Chatham's specific interests here?
Chatham's interest was their ownership interest in that pro rata share of the specific funding agreement. But even if their right was only contractual and they were only entitled to
You're
receive,
not a party to that funding agreement, right? Those merchant agreements, you're not a party to it.
well, true participants are never parties to funding agreements. True participants are, in effect, only participants in an agreement, but that confers upon them an ownership interest. But again, even if this interest was only contractual, we cited a case in our reply brief, Garrison Special Opportunities versus Fidelity National Card Services, in which the First Department held that where there was an interest that was subject to another party's contractual rights, the debtor was unable to assign that interest to a creditor, to a secured creditor, without it being subject to that contractual right that the participant had.
Well, your clients are well-counseled, sophisticated parties. If they wanted contractual language that conferred upon them the specific interest you're referring to, why didn't they bargain for that?
I can't speak to the past, but I would argue the same thing with respect to Arena. They are also sophisticated parties. They drafted all of these agreements. They specifically drafted the agreement, which was the assignment from PRFG to SPV. If SPV never took ownership of anything other than what was listed in the schedule, they could not have granted a security interest in those assets to Arena, and then Arena could not have effectuated an Article 9 sale to those assets.
Thank you. Your time on rebuttal.
Good afternoon, Your Honors. Chatham's arguments here all rely on the unsupportable contention that their interest is not within Article 9's rules. But Article 9 makes clear that participation interests such as Chatham's are squarely within its scope. And therefore, the Article 9 rules of priority and perfection apply. Under those rules, my client, Arena, was a senior secured party with a first priority perfected interest in all assets of its borrower, the SPV. Those assets included the receivables that were sold to the SPV by its parent, PRFG, including those in which Chatham claims a right.
But Chatham did provide partial funding for that, right?
I'm sorry.
Chatham did provide partial funding for the receivables, right? For the ownership interest, right?
What Chatham, they had a participation agreement with PRFG in which they would have provided partial
Right, but what
funding.
we're asking is that some of the listed things that Arena is saying that it's entitled to, it's not entitled to the full amount. It's only entitled to the portion or pro rata share that PRFG put in, not the portion that Chatham put in, correct?
No, that's incorrect. The assignments, what the assignments transferred, and my colleague here made, a misrepresentation when he stated that that the assignments, I think in his terms, entirely transferred the entire share. That Schedule A, while it does break out certain percentages, if you look at the language of the receivables purchase agreement as well as the assignments, and that's in Section 2.1 of the receivables purchase agreement and Section 2 of the assignments, it's clear that what's being transferred under those assignments is very encompassing. It's not just the receivables themselves, it's everything related to the receivables, and it's certainly not
You
a
have to agree
subdivision.
From a commercially reasonable sense, that when Chatham was buying into this, that it undoubtedly had to have thought, and maybe the agreement says something else, but they undoubtedly had to have thought that they were purchasing a part of the receivables, not just the right to collect if money comes in.
I'm not sure what entitlement Chatham would have to assume that when the language itself says that they're
I'm not saying that they'd
entitled.
assume it. I'm saying one would reasonably assume that when they were putting this money in, they were putting the money in to be an actual participant in the receivable, not just in the collectible.
It's incumbent.
Maybe 4.2 says something else. I'm not excluding that possibility, but it seems to me that that would be the starting point.
I mean, I think it's incumbent on a party entering a contract to understand what they are contracting for and which in this case was clearly the collections and not the receivables writ large.
In the context of your motions, is a little bit more of a procedural question. Did you, as the defendants, ever ask for a declaration that plaintiffs were not the sole owners of the Chatham purchased receipts, or you just wanted that cause of action dismissed?
I'm sorry.
Did you put in your summary judgment motion a request that this court declare that plaintiff was not the sole owners of the Chatham purchased receipts? Was that something that you requested in your papers?
I'm not familiar with that part of the papers. I don't believe that's right.
Thank you.
You just wanted the action, the complaint dismissed.
Right.
That cause of action dismissed, right?
The first cause of action
Yes.
for a
Right.
declaratory
For-
judgment.
Thank you.
Just a couple of points, Your Honors. With respect to the assignment, the conveyance of the receivables was specific that it was only transferring PRFG's interest in the receivables. And the specific Schedule A, again, lists percentages. It doesn't list anything else. Also, the fact that Arena was aware of Chatham and other participants' existence, specifically by virtue of the fact that the credit agreements provided that the participants were the ones that were going to be paid first in the waterfall sections with respect to distributions on collections, they cannot now claim that they took their right subsequent to our right coming into existence, not subject to our right. And that was the case of Snow Machines versus South Slope Development. What we have here is very simple. Chatham was entitled to its pro rata share of collections by virtue of its pro rata ownership. SPV never took ownership or control over Chatham's interest. Because SPV never took ownership or control over it, they could not grant a security interest to Arena. When Arena conducted the Article 9 sale, which was selling specifically the collateral, and the collateral again defined as SPV's assets, it never sold Chatham's interest.
In order to accept your argument, would we have to read out of the definition of collections the words proceeds of?
I don't think so, Your Honor. I don't think so. I think that ultimately the parties entered into a transaction where Chatham was entering side by side with PRFG with respect to the specific clients, and they at all time maintained an ownership interest with respect to their pro rata share of what they invested. If the bench has no further questions, thank you, Your Honors.
Thank you. Thank you both. People v. Shanasia Frazier.
Good afternoon. Rena DiFrancesco representing Ms. Shanasia Frazier. May it please the court. This case calls for the minimum sentence. Ms. Frazier has shown that she is successful.
So I'm trying to do the math. Should she be out in August, or she's not out, right? She's not out now, but she's around August would be her release date, her early release date?
No, she is not out now. Yes, I believe so. Her release date will be soon. So we are asking the court to reduce the sentence.
So you want us to reduce the sentence to 1 to 3. She had originally, when she pled guilty, she was promised, well, she was supposed to enter the program, and then if she completed the program, she would receive, I forget what sentence she would receive. And if she failed the program, she would receive 2 to 6, right? If she failed the conditions, she would receive 2 to 6, right?
Yes, if she
And then she actually did not meet the conditions of the plea, and as opposed to getting 2 to 6, she received 1.5 to 4, right?
Yes, this is true. But she didn't receive the minimum sentence that she could have. And even though it's true she didn't complete the programming, the reasons for this are extremely important. She had lost the support that was really propping her up. She had lost the housing that she was released into, the city-supported housing. She had lost access to her health insurance.
With regard to losing that housing, at the inception of this disposition, there was discussion about that housing being a vulnerability, right? Not knowing whether, in fact, the mayor's committee would continue funding that housing, and that if that happened, they would continue to kind of pull her into Micah Task to find another placement for her, right?
I believe so, Your Honor. And even though this was the case and what they had discussed, Ms. Frazier was still able on her own to find housing. She was able, through her own efforts, to find stable housing. So she showed that stability on her own. She did eventually lose access to her health insurance. She lost multiple extremely important resources. Also, all of this happening within the COVID-19 pandemic, and this is extremely important context to have. She didn't, as the respondent had stated, she didn't purposely or intentionally leave programming. She really wasn't able to continue with programming. It wasn't of her own volition. The lower court itself recognized this, that her issues with completing treatment had all to do with insurance and nothing to do to her.
As I suspect your friend will bring this up, so I'll give you a chance first. Do you want to address the appeal waiver?
Yes, and yes, there is an appeal waiver here, but there are multiple issues with the appeal waiver. The timing of the introduction of the waiver is incredibly problematic. She had already admitted guilt to the offense when the court
That's
introduced...
not a bar to the waiver being a good waiver, especially where here the waiver follows the model colloquy, right?
Yes, for the most part, but still looking at all the totality of the circumstances here, there was, for example, no written waiver that we can see. So even though...
well, we don't have one in the file, but there was reference to a written waiver during the allocution.
Right, because this was virtual, because as you mentioned, it was during COVID, so it was virtual. But there is reference to the written waiver. There's reference to counsel signing the waiver on your client's behalf.
And counsel having gone to visit your client prior to the calendar call and gone over the waiver with her.
Yes, counsel did mention this, but again, without this written waiver, we have no idea what that written waiver...
But we have the oral colloquy, which again follows the model colloquy.
And so the oral colloquy itself, besides the timing of the oral colloquy, which again came after she had already admitted guilt to the offense, there is more here. First, she's a vulnerable client. She has very documented mental health issues. She does have a lack of criminal history, basically no
Didn't the
criminal...
court go over this with her, asking her whether she understood what was going on, whether she wanted to plead guilty? I mean, wasn't there some acknowledgement of her status, whether she understood or did not understand?
Yes, but the court never asked whether she had herself understood the waiver, the written waiver, and so that's missing here as well. And further, the court...
Well, the defendant admitted that she had spoken with counsel about the plea, its conditions, was fully satisfied with counsel's representation. She said she was enforced or threatened into pleading guilty. So there was an indication by your client that this had been discussed that the plea and the waiver had been discussed with her attorney. But you do have time on rebuttal.
Thank you.
Good afternoon, and may it please the court. Owen Braley for the people.
So if you want to start with the waiver?
Yes, Your Honor. The waiver signed at the plea proceeding was valid, and it foreclosed the defendant's right to appeal on these grounds of excessive sentencing. As Your Honor,
There's also an oral waiver.
I'm sorry, what?
There's also an oral waiver.
Yes, though the written waiver is not in the file, the oral waiver, the judge went through the model colloquy, confirming with the defendant that she understood at every step along the way. If you look at the minutes, the judge began by distinguishing between the trial rights and the appeal rights as being separate and distinct, and clarifying that the trial rights were given up as a consequence of the plea and the appeal rights were given up as a condition of the plea. The defendant confirmed that she understood that. Again, the judge then went through to explain that certain rights do survive the claim, specifically the right to counsel. The judge was incredibly clear, saying that if a defendant cannot afford the costs of an appeal or of a lawyer, the state will bear those costs. The defendant confirmed again that she understood this, and the court went through explaining the types of claims that do survive the right to appeal. After all of this, the defendant, as you mentioned, confirmed that she had spoken with her attorney previously to the calendar call as well as in person and reviewed the written waiver. So although there is not a copy of the written waiver in the appeal record, people would submit that a totality of the circumstances does show that the defendant understood the nature of the rights that she was giving up.
Your adversary mentioned that the reason why this treatment disposition was not successful had to do with Medicaid health insurance issues. But a part of the reason why she was deemed not successful was a new arrest for arson, right?
That is correct. The defendant was arrested during her treatment phase of the case for a similar arrest in Queens for arson.
And a condition of this treatment disposition was that she not be rearrested on any new matters, right?
That is correct. And I would just like to point out at the beginning of the sentencing appearance, before the people consented to lowering the promised sentence from 2 to 6 years to 1.5 to 4, the people did state that they would not be giving the defendant any additional opportunities. So that being said, I believe it's reasonable to see that they gave the defendant opportunities for missing the treatment, understanding that COVID and things outside of her control contributed to this. It wasn't until she was rearrested for basically identical conduct that the people then asked that she be violated.
That's in September of 2023, right?
Queens arson? I don't know the exact date, but that tracks, yes. I believe the plea was taken in February, so the timeline there makes sense. However, given that this was in the treatment the treatment part of Bronx Court, the court was well aware of her vulnerabilities, her struggles. A pre-sentence investigation was completed before this. The plea was taken, and again, as I said before, the people did agree to come down on the promised sentence of 2 to 6 years to 1.5 to 4.5 at the time of sentencing, in light of all the facts that defendant is now bringing back up in front of this court. So if the honors have no further questions, the people would ask that the judgment of the lower court be affirmed.
Thank you.
Your Honors, increased incarceration is not the answer here. Ms. Frazier should be getting treatment within the community. That is the best thing for her psychiatric health. With all of these issues connecting with treatment, she had been actively trying to connect with treatment, working with her task counselors. With the right resources, she has shown that she really is successful. Prior to this offense that happened in the peak of the COVID-19 pandemic, she had basically no criminal history. She was successful in this program for over a year before.
September 23 is past the height of COVID.
Yes, but all of the things that happened in that time period are so important. She, again, lost her housing. She, and even then was still able to find housing for herself, was still able to find some stability. She had lost her insurance, her Medicaid insurance, and was unable to connect with treatment because of that. And again, like the lower court itself.
Had she before been working as a flagger?
Yes, she has a good employment history. She had received her GED. She has done stuff for herself that shows that really with the right tools, which she has now, she has the support of our office's reentry team, the Bronx Defenders reentry team. We are here to support her with these tools. She will be successful. And so that is the best thing for her. The best thing for her would be that she should be getting treatment for her psychiatric health within the community. Incarceration is just not what's best here. And so I do ask that your honors use your interest of justice powers to reduce her sentence to the minimum.
Thank you. Thank you both.